All right, everybody, welcome. Thank you so much for joining us for our webinar today. My name is Raylene. I'm one of the advocates here at Standpoint, and I am just here to get us started. So first and foremost, I'll tell you a little bit about Standpoint. Most of you probably know about our organization, but for those that don't or may listen to this later on YouTube, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do include our annual New Laws training, which is coming up very soon, so you should check out the website or our social media to find out more there, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors and advocates connect with callers to provide resources, safety planning, listening, and helping callers identify possible options and next steps. So this webinar is being recorded, as you heard, and it will be uploaded to Standpoint's YouTube page later on. The link to the recording will also be emailed out to our listserv, so you'll be able to access it there. And I will be putting the information and the PowerPoint in the chat as soon as we get started here, so you'll have access to that. And to introduce our presenters today, we have Sammy and Maddie that are with us. So Sammy joined Standpoint in May of 2024. So she's our newest team member. We're super excited to have her. She's a graduate of New York University School of Law and has focused her legal work on helping victims and survivors navigate the family court system. Prior to joining Standpoint, Sammy worked at Central Minnesota Legal Services, where she represented survivors of domestic violence in family court proceedings, including custody, divorce, and orders for protection. As a staff attorney at Standpoint, Sammy provides legal advice and consultation on family law issues affecting victims and survivors. And we also have Maddie, who joined Standpoint's team in October of 2022. She comes from St. Louis County, where she began her work in the field of domestic violence in 2016. Her primary experience is in providing civil and criminal legal advocacy to victim survivors from within both a shelter and resource center setting. In her prior role, Maddie served on a team within a police department, assisting in the facilitation of a coordinated community response to domestic violence-related crimes. She's affiliated through board and committee service with nonprofits in northern Minnesota, whose missions involve reproductive justice, gender-affirming healthcare, and expanding access to affordable housing. Maddie has a master's in advocacy and political leadership from the University of Minnesota Duluth and received her bachelor's in communications with a minor in women's studies. And with that, I think I will turn the presentation over to Maddie and Sammy.
All right. Thanks, Raylene. And thanks, Raylene's cat, who also graced us with her presence. Good afternoon, everyone, and welcome. We have got a webinar for you today on supporting pro se victim survivors in family court. And in case there's anyone who's unfamiliar with the term pro se, it is a legal term that comes from the Latin word for oneself, meaning unrepresented by an attorney and representing themselves. Also, there's many different types of cases that family court handles, such as child support, adoption, orders for protection. But for our purposes today, we're going to focus solely on divorce and custody. So here is our agenda. So you have some idea of what to expect. This is not going to be an instructional on the whole divorce and custody process. We chose the areas we're planning to focus on based on where advocacy has the greatest capacity to be helpful. And we know that most advocates are not going to have the time to, hold their client's hand through the whole process or help them fill out, stacks of paperwork. And of course, we can't give legal advice. But the information we're presenting today is intended to sort of give you a checklist of helpful things to go over with them, and where you can be redirecting their attention and energy, so they're being as productive as possible and not undermining themselves by focusing on the wrong things. But just a warning, maybe you can tell from the agenda, we are going to be jumping around a little bit with this approach. Okay, so we're going to start by acknowledging some realities and the need to set expectations when your client asks you for help finding an attorney. This is something that most of us hear daily as advocates, and it can cause a little bit of anxiety because we know that the majority of people are not going to be able to secure an attorney for full representation unless they have money. And even if they do, they might not be able to have them do everything they need them to, unless they have access to funds, on a significant and ongoing basis. And that's because having a lump sum to retain an attorney, it doesn't mean that it's going to be anywhere near enough to get them through an entire divorce or custody case, especially ones that are as complex and contested as the types that we see in the domestic violence world. Many people I've worked with have spent, their life savings on hiring someone only to need to let them go in the middle of the case because they ran out of money. And that's not to say that this means that it's not worth it. But I always tell people if they're looking at hiring someone that this is the reality of the financial cost, so they need to plan accordingly. And if we know that they income qualify for legal supports, though, it can be easiest as an advocate to respond to this request with the number for legal aid, even though the chances are very low that they'll be appointed someone for full representation and in the time frame that they need it. And this does not mean that, they shouldn't call and do that intake to get their name in the system. They definitely should. This creates a conflict of interest if their abuser tries to use them. And there's always a chance that they'll get lucky and get appointed someone. But what we see time and time again is victim survivors putting the majority of their time into finding representation and not into preparing to represent themselves. And that's why it's important to set expectations. So being clear that there's not some secret, magical free attorney program out there that you're gatekeeping. I think a lot of people have a misconception that finding a free attorney is just a matter of looking hard enough or calling enough, law firms to see if someone has pro bono hours they're looking to give away to a sympathetic case. But that's just not really how it works. Most counties have a small handful of programs and you simply call and do an intake and wait for a call back. But there are other resources. Law Help MN is a really good database to find them, as well as a good tool for getting some user-friendly instructions on how to navigate legal matters. There are legal clinics, which are often programs of legal aid. These are good options for getting some step-by-step assistance with paperwork and some legal advice. But like with most things, they do require an intake process and there are wait lists. So they would want to call and apply to these immediately. And then the next thing is that the family court forms themselves have detailed instructions and important information. So they can get a lot of their questions answered about the process by reading them. And then some jurisdictions have really good law libraries with an attorney on staff who can walk them through the basics. But the main takeaway is that a lot of these resources are going to give people access to legal advice from attorneys. Programs like Legal Aid and the Voluntary Attorney Program provide a lot of assistance in the form of ongoing consultation or partial representation. But I've talked to a lot of survivors who seem, I think, hesitant to meaningfully engage with anything less than full representation. I think because it feels like it's opening the door to having to present their case like a lawyer in a trial setting in court, which is obviously really intimidating. And that's probably why we see so many people spend their time searching for an attorney instead of doing any of the legwork. And then deadlines approach and they're unprepared and they end up with bad outcomes. So talking to people about the risks of that approach is a good idea. There's also a lot that we can say to make these resources more approachable and help people use them effectively. Here we have some specific suggestions that advocates can make around that. And the first thing is to be clear when calling legal aid and other programs that you do want legal advice and any assistance you can get, even if it doesn't come with full representation. And then after you've done those intakes and you're waiting on a call back, pull up the forms and instructions that go with them and just start filling out a draft version prior to any consultations. Doing that is going to help you identify some of the more technical questions that you have, which you should be writing down, because you shouldn't assume that you're going to remember all your questions. I think it's kind of can be intimidating when you finally do get an attorney on the phone. So that's a good way to start getting organized. And then the next thing is to understand what legal advice actually means, which is, should I do this rather than can I? A legal consultation is going to be very informational on the process, but it's really a unique opportunity to answer the should I. So have them start framing their questions this way in their mind, and then start collecting information that's going to be needed, social security numbers, financial statements, etc. Um, be organized, make sure your voicemail isn't full, that you're free during the time periods you're expecting a call back. Read your court notices so you know when the deadlines are and what they're for. And then be prepared and take notes during your consultation. We can't assume that all of this is obvious to people in crisis. And we know from our work that many people just aren't doing these basic things. So spilling it out is helpful, and it puts the focus on the things they can control throughout the process. All right. And Sammy, I think this is you.
Yeah, so we wanted to take a few minutes and just go over kind of the general steps in a family court case, mostly a custody or a divorce case. And this is going to be pretty simplified. There are usually going to be more hearings than just what's listed here, but this is sort of a broad outline of how these cases tend to go. So the first hearing in these cases is going to be an initial case management conference, which you might also hear referred to as an ICMC. And that's a less formal hearing where the judge basically wants to figure out what are the best next steps in this case and what do we need to do to make sure this case is moving forward. And so one thing that the judge will do is ask both parties if they want to participate in any alternative dispute resolution. And that's things like mediation or a social early neutral evaluation. And some judges do a really good job at explaining to both parties what alternative dispute resolution is and letting them know that it's an option. They're not required to participate, but they can, and it can be helpful. Some judges don't explain it. They just kind of expect that both parties are going to show up to this ICMC and already know what this is and whether they want to participate in it. So one thing that advocates can do that can be really helpful for their clients is just help explain what alternative dispute resolution is and kind of some pros and cons of it. And we'll go into more detail on a few pros and cons a little bit later in the presentation. But if you're able to go over that with your clients before this ICMC, it helps them know what to expect going into that hearing, and then they're not surprised or overwhelmed when the judge starts using all these terms that they might not have heard before this case started. The next steps in the case kind of depend on what everyone wanted to do at the ICMC. So if the parties do agree to participate in mediation or some other form of alternative dispute resolution, that'll be the next thing that gets scheduled. And if it's a process through the court, like in the counties where they have a social early neutral evaluation program, then the judge will make sure that the parties understand the process for getting that scheduled. If they're going through a private mediator, then it'll be the party's responsibility to reach out to a mediator and make sure that gets scheduled. There might also be other types of alternative disputation other than just an early neutral evaluation. Sometimes it may be appropriate to ask the judge to appoint a guardian ad litem if there have been allegations of harm towards the child. Sometimes parties can ask for a custody evaluation. Not all judges want to order a custody evaluation immediately. Some prefer that you try mediation first and maybe proceed to a custody evaluation if that doesn't work. But in some counties, you could ask for a custody evaluation at the start of a case. Custody evaluations tend to be very expensive if you're not in a county that subsidizes them. So that's not an option for all clients, but it's something to be aware of if you're working with someone who can afford it, or if they're in a county that does subsidize it. So for example, Hennepin County has a really good program that charges for custody evaluations based on income and makes those a lot more accessible to people. One other thing that might happen at an ICMC is if the responding party does not show up to the ICMC, as long as they've been served properly with all of the paperwork, if they just don't come to court at all, then the person who filed the paperwork can ask the court to proceed by default and just enter a decision without that party being there. In most cases, they're going to need to schedule a separate default hearing to do that. But that's something the judge can do at the ICMC. They can say, yep, I see that the other party is not here. We're going to get that default hearing on the calendar. And so it's really important to make sure that if you're working with a client who has been served with divorce papers or with custody papers and they've gotten notice of an ICMC, they need to go. Because if they don't participate in the court process, decisions can be made in their absence. And those are not going to be decisions that they're going to like. And it's also important for them to know if the other party doesn't show up. The other party can't just, prevent this divorce from happening by refusing to show up. Sometimes that comes up where you'll hear clients say, I know he doesn't want to get divorced. What if he just refuses to come to court? And if he refuses to come to court, then the court can enter a default order without him being there. The next thing on this list is temporary motions. These don't happen in every case, but they're important to know about because they do come up sometimes. A motion is basically anytime one of the parties is asking the judge to make a decision about a disputed issue in the case. And these are called temporary motions because they're happening before the case is resolved. And so usually one of the parties is asking the judge to make a decision on a temporary basis. They're saying, I know we haven't finished our custody evaluation yet, or we're still, going to have a few more sessions of mediation, or we have a trial on this issue on a temporary basis before we get to that point. And that could be something like a parenting time schedule. So if the parties cannot agree on how much parenting time each of them are going to get while the case is pending, one of them could ask for a motion hearing and file paperwork to ask the judge to make a decision about what parenting time should look like while the case is pending. Same with child support and spousal maintenance. So if one of the parties needs some financial support, they're not able to support themselves and, wait potentially months and months for a final order, they can ask the court to make a decision on a temporary basis so that they can go ahead and start getting some financial support. And judges don't always want to issue temporary orders. So sometimes in these temporary motions, you really have to explain why it's necessary for the judge to decide this issue now. It's not just that, the parties aren't agreeing. It's that one party maybe isn't getting parenting time, or they're getting very limited parenting time and it's impacting their relationship with the child. Or, one party really needs this temporary child support order because they were used to, having the income of the other parent while they were together, and now they're caring for the child with limited income or sometimes with no income. So there is that financial need. So that's just something to keep in mind is let your clients know that they're going to need to be prepared to explain to the judge why a temporary order is necessary and why they can't just wait until there's a final agreement or until there's a trial. And in these temporary motions, the parties have to present similar information that a judge would need if they were making a final decision on the issue. So if it's a temporary motion on child support, they're going to need to present income information the same way they would need to present that information if they wanted a child support order in the final judgment. If it's about parenting time or custody, they're going to need to present information about the best interest factors, the same way that they would do that if there were a trial about custody or parenting time. Next on the list is a pretrial. This is usually considered kind of the last attempt at settlement. And each judge can be a little different on what they want a pretrial to look like. Usually they will send out a notice to both parties, letting them know what they expect the parties to come to the pretrial prepared to do. So some judges want them to come with a list of any issues that they still disagree about. Some judges want them to have to bring some financial documents maybe bring a list of any marital assets that they still disagree about, maybe bring pay stubs or W-2s. Some judges want to know an estimate of if this case did go to trial, how many witnesses would each of you call? How long would we need for this trial? Usually, the judges are going to want the parties or the attorneys, if there are attorneys on either side, to make one last attempt to communicate and try to reach a settlement. Now, if both parties are pro se and there's an order for protection in place, there's some limitations on how much the judge can really ask them to communicate and reach a settlement. But if there's no order for protection, or if one party does have an attorney, the judge probably is going to ask them to talk one more time about these issues and see if they can reach an agreement. And if at any point during the case, if an agreement is reached, it can be put onto the court record and incorporated into a court order. After the pretrial, if there is still no agreement, then at that point, the judge is usually going to be willing to schedule a trial. And that trial will be the final court hearing. It's the opportunity for both parties to testify and present their evidence and ask the judge to make a final decision based on whatever they're presenting. And so after that point, that is when they would get a final order. So it would either be because they've reached an agreement and asked the judge to enter their agreement into a final order, or because they've gone to trial and the judge has made a decision on what to put in a final order after a trial. Sometimes the final order is not the last thing that happens in a case. There can be motions filed after the decree. And sometimes these motions are necessary. Sometimes things change. A parenting time schedule that gets set when a child is 5 doesn't always work by the time the child is 12. And in the best circumstances, the parents would be able to agree that the parenting time schedule is no longer working, and they would set up a new schedule, and they could sign a written agreement about what that new schedule is going to be and just submit that written agreement to the court, and a judge could sign off on that. But in a lot of cases, the parents can't agree. Maybe they don't agree that the schedule needs to be changed at all, or maybe they agree it needs to be changed, but they don't agree on what the new schedule should be. And so that's where these post-decree motions can come up. So one of the most common reasons somebody brings a post-decree motion is to change a parenting time schedule. Sometimes there'll be motions to change custody, which is a higher bar than changing a parenting time schedule, but we do see those motions pretty frequently. Sometimes there will be motions to change the location where a parenting time exchange is happening, or to change a child support amount if someone's income has changed. Less common reasons, we do see motions sometimes where parents joint legal custody can't agree on one of those legal decisions, like where their child should attend school next year, or some kind of medical decision has come up and they don't agree, and they can ask the court to make that decision. We also see contempt motions, and those have a pretty specific process. They're a little bit different than other types of motions, and so we're not going to get into a lot of detail about the process for contempt motions today, but they are a type of post-decree motion that exists, and you can always reach out to Standpoint if you have any specific questions about contempt motions. Okay, and so now we wanted to go over a little bit about motion procedures. And all of these procedures apply both to temporary motions that might be filed while a case is pending, and to any post-decree motions filed after the final order. And we know that you're not necessarily going to be drafting motions with your clients, but you can help them know what to expect when they are drafting their own motion. Because motions are sort of weird. Not everybody knows what the process is for a motion, and sometimes it's not very intuitive. So when a client is writing a motion, there's an affidavit that they're going to need to include. And in their affidavit, they should include any information that the judge should know. So anything that you would want a judge to take into account when making a decision on this issue, put it in the affidavit. And that includes any exhibits. So if there are text message screenshots that would be helpful for the judge to see, you can attach those screenshots to the affidavit with the motion so that the judge can see them. If there are medical records that are relevant to the motion that the judge needs to see, you can attach those. There are photos, those can be attached as exhibits. And the reason that's really important is that the judge is not going to take additional testimony at most motion hearings. So it's not like an evidentiary hearing that some of us might be used to seeing in order for protection cases, where you have your order for protection petition, but then you also get to testify and present additional documents. It's very different from that. The judge only considers the information that is in the affidavits from the parties. So if it is not in whoever files the motion, if the information is not in their affidavit, they're not going to be able to present that additional information at the motion hearing, and they're not going to be able to present additional documents. At the motion hearing, all they can do is make an argument to the judge about why the information they've already submitted meets the legal standard for whatever they're asking the judge to do. There are some really important timelines to follow when filing a motion. And if a party misses these timelines, the judge might not hear the motion at all, no matter how good the motion might be, how important it might be. If you miss the deadlines, the judge has the authority to just say, I'm not going to hear this motion. I'm going to cancel the hearing. So whoever's filing the motion, they have the first deadline. They need to contact the court and obtain a motion hearing date. And that motion hearing date is going to be at least 21 days in the future, because they have to file and serve their motion 21 days before the hearing. And if they are planning to serve their motion by mail on the other party instead of personally, that is allowed, but they need to add 3 additional days to their deadline. So instead of 21 days before the hearing, they would need to serve it 24 days before the hearing. And then the other party has kind of 2 options for their deadline, depending on what they want to ask the court for. If all they want to do is ask the court to deny the original motion that was filed, all they're saying is like, I don't think this motion is a good idea, please deny it, then their deadline is 7 days before the hearing, because they're not raising any new issues. And again, if they're planning to serve their motion by mail, they also have to add 3 days to that deadline, so it would be 10 days before the hearing. But if they are raising any new issues, so anything other than just denying the first party's motion, then they have to file and serve their motion sooner. They have to do it 14 days before the hearing, or 17 days if they're serving by mail. So, for example, if the first party says, we really need to change our parenting time exchange location. We're doing it at the school right now, and that's just really not working. We need to move it to a police station parking lot. And that's what they're asking for, and they file that motion and serve it 21 days before the hearing. If the other parent is just saying, no, I want to keep having our exchange at the school, just deny this motion, then they can wait until 7 days before the hearing to file their response. But if they're saying, no, I don't think we should change our exchange location, and also I think I should have more parenting time, that's raising a new issue. And so they're going to need to file that 14 days before the hearing. And if they do raise a new issue like that, the first party, the one who filed the original motion to change the exchange location, they have an opportunity to respond to this new issue of the parenting time schedule. So their deadline to respond is 7 days before the hearing, or again, 10 days if they're planning to serve their response by mail. A really common question that comes up when talking to clients about motions is 21 days is a really long time. What if this issue is? And in some circumstances, it is possible to get the court to waive those deadlines, but it's a really high bar. So it's not just, it's going to be really annoying to have to wait 21 days. The parents are going to have a bunch more disagreements with each other in those 21 days when they're waiting for the court to hold the hearing. But it's where there is some kind of urgency, not caused by a lack of diligence, that makes the normal deadlines unworkable. And so usually that's going to be something like a risk of harm to either the child or to one of the parties. So, for example, if Child Protection has opened an investigation and right now there's an order for both parents to have parenting time, the Child Protection investigates and they say, actually we don't think this other parent should have parenting time. We think there is a risk of harm to this child and you need to not allow them to have contact with the child. That might be a situation where you file an emergency motion and say, there is a risk of harm. The court needs to amend the parenting time order so that I'm not required to send my child to parenting time to this parent who Child Protection has said is a risk. That's an emergency because there is a risk of harm to the child. And there's kind of two types of emergency motions, and these get mixed up a lot. So there's an emergency motion and an ex parte motion. And not every emergency motion is also ex parte. Ex parte means that the motion is filed with the court and an emergency order can be issued before the other party is given any notice that a motion has been filed. An emergency motion, you would file the motion with the court and serve the other party with the motion at the same time. And there's a higher bar to file a motion ex parte because you're not giving any notice to the other party, and that's not usually the way the court likes to do things. And so to file an ex parte motion, you have to show that there is some kind of risk of harm if the other party is given notice before an emergency order is issued. And one thing to keep in mind is this doesn't mean the other party is never going to get notice that a motion has been filed. The difference between an emergency motion and an ex parte motion is really just when the other party gets notice. So with the emergency motion, they get notice at the same time that the motion is filed. And with an ex parte motion, it might be an extra day or two because they get notice when the judge issues an order instead of when the motion is originally filed. And the reason it's important to know that distinction is because if you file a motion ex parte when it doesn't meet that standard to file without giving notice to the other party, the judge can deny it. Even if it might meet the standard for an emergency motion, they could say, nope, you didn't give notice to the other party. I'm not issuing an ex parte order. I'm denying this motion. And you can refile it as an emergency order, but it just adds delay to the proceedings. And the other part of this rule to keep in mind is the part that says urgency not caused by a lack of diligence on the part of the moving party. So if the party filing the motion has caused delay, then that might not qualify to the judge as an emergency anymore. So an example of that we see come up pretty frequently is that sometimes, there might be a parent withholding parenting time from the other. And, maybe the parent who's not getting their time calls the police, but the police aren't able to help them. They keep asking to see the child, but the other parent keeps saying no. They wait maybe 6 months, and then they try to file an emergency motion, and they say, I haven't had parenting time in 6 months. This is an emergency. I don't want to wait 21 days to restart my parenting time. Most judges are going to look at that and say, this has been going on for 6 months. Why is it an emergency today? And they're going to deny the emergency order, and you're going to have to, refile a motion and wait out that 21-day timeline. The better practice in that situation would be, once they've been made aware that parenting time is being withheld, they've tried to call the police and the police aren't able to help enforce that parenting time order, they can file an emergency motion pretty immediately. And then if they've been having consistent parenting time with that child, they can make an argument that the sudden cutoff of that parenting time and not having any contact with that child is emotionally harmful to the child because of the risk that they're going to feel abandoned by their parent. There is emotional harm that happens when a parent is suddenly absent. And so it's much more likely that a judge is going to be willing to issue an emergency order if it's filed very soon in time after the withholding starts rather than waiting several months. You also need to make sure to include evidence to show why this is an emergency, and it needs to be really specific evidence. So, for example, if there's a concern about a parent drinking during their parenting time, it would not be sufficient to file an emergency motion with an affidavit that says, the other parent has a history of alcoholism and he's been acting really weird recently. I think he's drinking again. Because that doesn't really give the court enough information to know that it's an emergency. The court doesn't know what it means that he's acting weird, and they don't know how that impacts the child, even if he is acting weird. And so a better emergency motion affidavit could say something like, during his most recent weekend of parenting time, my child's father sent me a text message that didn't make any sense and had a lot of typos in it. And you can attach that text message screenshot as an exhibit. When I asked him what this message meant, he didn't respond. I tried calling him to see if something was wrong, but he didn't answer. When we used to be together and he would get drunk, he would also send me texts with typos and would refuse to answer any follow-up messages. The next morning, I texted him to ask if everything was okay. He got very defensive and he accused me of harassing him and told me I didn't have a right to know what he did during his parenting time. And again, you can attach that text message as an exhibit. This is also how he used to react when we were together and I would ask him if he had been drinking. When I went to his house to pick up our child for my parenting time, I saw several beer bottles in the trash can. So that paragraph is much more specific. It gives the judge a lot more information to know exactly why this party thinks the other parent is drinking and how it connects to the child, because it shows the judge that the child was present when the other parent was drinking. And one thing to note, though, is even that paragraph, even though it's much stronger and much more likely to convince a judge to issue an emergency order, it's still not a guarantee. It's still mostly kind of circumstantial evidence. The client's kind of guessing that this is probably what's happening. And for most judges, that kind of evidence that I described in that paragraph would be enough because it's a pretty good likelihood that this behavior is being caused by drinking. There are some judges that might not be willing to issue an emergency order on that basis. So, and it's really hard to get direct evidence of another parent drinking. So, that's just something to be aware of. You want to include as much information as possible, but if you're not able to get direct evidence, some judges just aren't going to be willing to issue the emergency motion. I wanted to give an example as well of something that might qualify for an ex parte motion. So sometimes people are really worried that if they give notice to the other parent that they're filing a motion, that the other parent might flee the country with the child, and then it's going to be much harder to enforce any custody orders. And so someone might write, the other parent is really unhappy with the current court proceedings, and I'm worried he'll take our child to Mexico and refuse to bring her back. That's not going to get a judge to issue an ex parte order because that's not really specific. It's just speculation saying, I think he's going to take her to Mexico. There's not enough specific information to allow the judge to make that inference that there's a real risk of him taking the child to Mexico. But if there are specific facts supporting the client's worry, they could include those in the affidavit. So for example, they could say, my child's father has told me that no matter what the court says, our daughter will always live with him. They could include information that the other parent has the child's passport. Sometimes, if the child's young enough, they might let something slip, where you might be able to say, my daughter told me, Daddy says I'm going to see grandma soon. Maybe grandma lives in Mexico and grandma can't travel because she has health conditions. So the only way the daughter would see her is if she was going to Mexico. And sometimes in those cases, there will even be more explicit threats. Sometimes the other parent just says, like, I'm going to take her to Mexico. I don't care what the court says. Or sometimes they'll even buy plane tickets and you'll be able to have a record of those plane tickets. And so those are cases where if you can connect the risk of him fleeing the country to receiving notice that a motion is being filed, that's where a judge might be willing to issue an ex parte order. So there are some really specific things that you have to include in an emergency motion or an ex parte motion in addition to kind of the substantive things that I just went over. And that's kind of straight from the general rules of practice. If you want to look up the rule, it's Rule 303.04C. And the reason these are so important is because since they are in the rule saying that this has to be included, if these are not included, the judge can just dismiss an emergency motion, regardless of what the motion is about. It might be a really good motion with a lot of good information, and a judge could say, well, you didn't include these requirements, so I'm dismissing the motion. So you have to include information about why emergency relief is requested, which is going to relate to, those specific facts that I went over. What relief specifically is being requested. So it's not enough to say, I think dad is drinking during his parenting time. You've got to tell the court, what are you asking the court to do about the fact that he might be drinking? You have to disclose any other attempts to obtain the same or similar relief. So maybe if you're asking for alcohol monitoring because he's drinking, if the client has asked for alcohol monitoring in the past in the same case, then they're going to need to disclose those attempts and what happened when they asked for alcohol monitoring. And if there's been any prior attempts to obtain emergency relief, they have to list the name of the judicial officer that the request was made to. And if any prior request was made for the same or similar relief, they're going to have to explain what new facts are presented supporting this motion. So if they've asked for alcohol monitoring before and it was denied because maybe there wasn't enough evidence that the other parent was drinking, they'll have to explain, what new evidence is there now that he is drinking to support this new request for alcohol monitoring. And they also need to include a proposed order for the court. And that's important because in most motions, you have the option to include a proposed order, and some judges require it, some counties might require it, but it's usually not a basis to just deny a motion. But for an emergency or an ex parte motion, it is in the rules that you have to include a proposed order. And if you're filing the motion ex parte, you also have to include a written statement, either that the party has made a good faith effort to contact the other party or their attorney and that they haven't been able to reach them, or show good cause why notice would not be required. And that good cause would be, what I went over about some risk of harm if the other party is notified before an emergency order can be issued.
All right, so now we're going to switch gears a little bit and talk about presenting abuse. And the first thing to know about that is what is not considered abuse in family court, which is things like emotional abuse, a wide variety, of course, of control tactics. These forms of abuse are simply not illegal, and they're not recognized in the statutes. And so when people tell me that they're going to court and they have to tell the judge about all these behaviors, I do tend to warn them that it won't carry as much weight as they maybe feel like it should. There may be some helpful ways to flesh out these dynamics and relate them back to the best interests of the children, but people do need to have their expectations in the right place, or they might end up feeling pretty invalidated or approach the whole thing with the wrong strategy. If you want to bring up these forms of abuse and you're just talking about how they impact you, it's probably not going to be useful. You need to be able to reasonably articulate with examples like Sammy was describing, if that behavior is having an impact on your children. If you can't do it, it could just end up being a distraction from your more persuasive arguments. That said, though, if there is physical abuse or behaviors from the abuser that are causing them fear of imminent harm, physical harm, they can present this information with the goal of the judge making a finding of abuse, which is an acknowledgement in the court file that the court has looked at the evidence and determined that domestic abuse has occurred. Now, this finding is based on the same definition of abuse as what's in the OFP statute. In practice, though, the evidentiary burden might be a little bit higher. So there probably needs to be a little bit more of a paper trail, reports made to the police, and OFP itself, medical records that document injuries of an assault. These would all support getting that finding. Without them, though, many family court judges might be hesitant to make that. So then the question becomes, where and when do they bring this up and present their evidence? And the answer is that it does depend on which path the case takes, of course. So it could be in mediation during the custody evaluation, or the trial, or in a temporary motion if one is filed. A good suggestion would be to organize their argument, that this abuse needs to be considered around the best interest of the child factors. We're going to get into these much more thoroughly in the next few slides, but the fourth factor specifically is looking at whether or not domestic violence has occurred. So stating that in reference to that fourth factor, the other parent has committed domestic abuse against you, and then moving on to presenting evidence of that. Now, the tangible benefits of getting a finding of abuse are that they trigger certain victim rights, and Sammy's going to get into them in more detail in a bit. But in short, it changes the presumptions around how custody should be awarded from joint to solely to one party, which is something that your client will want to remind the court of probably in their arguments. And that is not guaranteed. That it's gonna sole custody would be awarded to the victim. So they need to be sure that they have arguments around those other best interest factors. Basically, they just don't want to assume that if there's a finding of abuse, that's all that's needed for them to get sole custody. No matter what, they need to be focusing on all of the factors because they are weighted equally. So let's get into what those are specifically. One of the best pieces of information that you can share with and go over with your client are the 12 best interest of the child factors. These are the statutory guidelines the judge must use to determine custody. And so instructing your client to be considering them throughout every stage of the process is going to be really helpful. So telling them that all of the arguments that they're making, whether it's in the paperwork or with, the different court professionals or during the trial, if it ends up getting that far, should be articulated around these specific factors. And I do apologize, the next several slides of these are going to have a lot of words because we're going to go through each factor. They're really important for your client to be reading and, again, tailoring their arguments to. It's also going to give them a real sense for what the court's perspective is on what's important. So here they are. Number one here is the child's physical, emotional, cultural, and spiritual needs. And then importantly, how does the proposed custody or parenting time arrangement specifically affect your child's needs and development? Number two is any special medical, mental health, or educational needs that require special parenting time arrangements. What's their preference depending on their age? And of course, that preference is given more consideration the older the child gets and becomes a very important factor in their later teen years. Four is what we were talking about. Has there been any domestic abuse in the relationship? And what are the implications of that abuse as it relates to the children's safety and well-being? And a reminder that this definition under 518B is the same one that's used in the OFP statute. Five is, does either parent have any physical or mental health issue or chemical health issue that may affect your child's safety or development? And you might mention, if it's relevant, that having one of these issues, even a serious one, doesn't mean that the court is going to determine that you shouldn't have custody. They recognize that a lot of people have these issues and are good parents. We know, though, that abusers like to weaponize them. So just assuring them that this is just one consideration and it has to do not with the mere presence of a diagnosis, but specifically any negative impacts it's having on the kids. So do be ready to address what you're doing to prevent those impacts, but try not to give too much weight to those promises that the abuser made to take the kids away because you were hospitalized with depression, for example. And then moving along, 6 is that you need to describe the history and nature of how you and your child's other parent have provided care to your children. What is the willingness and ability for each parent to provide future care and meet their needs on an ongoing basis, and whether they are able to remain consistent in this as well as follow through with parenting time. 8 is about how changes to their home, school, and community will affect their well-being. And of course, some of these are inevitable when the parties are separating, but it is just something that the court looks at. 9 is about the effects of the proposed arrangement on the relationship between the children and each parent, and then also their siblings and other relatives. And then last slide, what is the benefit to your child in maximizing parenting time with both parents, as well as what is the detriment to limiting that parenting time with either parent, which is the most confusing factor, I would say. 11 is, will you or the other parent support your child's relationship with the other parent and encourage and promote frequent contact with them, which is conditional in the presence of domestic abuse? And then finally, what is the willingness and ability of both parents to cooperate in the rearing of your child, as well as maximizing of sharing information and minimizing the exposure of your child to parental conflict? This is one that I always point out because it's obviously a difficult thing to do when abuse is present and difficult to demonstrate while you're also navigating forms of abuse that the court doesn't recognize. Now we have what the statute says about the application of these factors. And these might be important things to share with your client as well. The first is that everyone who has a role in determining the outcome of the final order, whether it be the judge or someone like a custody evaluator, they are all required to look at all these factors and make a detailed finding on each one of them. They can't use one factor to the exclusion of the others. They have to all be weighted equally. They will consider that the factors might be interrelated, but they still have to make that separate finding on each. And then doing this is to promote the child's needs through safe, stable, and nurturing relationships with both parents. There is also a legal presumption that parents are both capable of being nurturing, and there are different ways of doing that. They're going to consider if they've determined that there's been false allegations of child abuse. And then we have the language in black on the bottom here around the rebuttable presumption that joint custody is not in the child's best interest if domestic abuse has occurred. So we're going to be redundant on this point, but it means that the court defaults to an assumption that one parent should obtain sole custody when there's been a finding of abuse. But the other important word here is rebuttable, meaning this presumption can be challenged by evidence that contradicts it. So it's not a hard and fast rule, it can be overruled. And also, just because one parent is awarded sole custody doesn't mean the other parent won't get parenting time and a substantial amount of it. This is a distinction that not everyone understands. Someone can have sole physical custody and still be ordered to provide regular parenting time, and refusing to do that can jeopardize their custodial rights. This part of the statute is also especially important when we think about legal custody and how important it is for the abused parent to avoid getting an order that requires them to negotiate and compromise with the abuser on every decision related to the child until they come of age. Because we know that abusers typically aren't interested in doing that. They're more interested in dominance, and they often use that open line of communication for further harassment and intimidation. So talking to your client about the benefits of using this presumption to avoid shared legal custody is important. Some other things for them to know when thinking about these factors is that the court shall not consider conduct of a parent that doesn't affect the parent's relationship with the child. So they don't care about infidelity, and making that the focus is only going to distract from the things that they do care about, and potentially make it look like a parent is just, angry about an affair and is motivated more by that than what's in the child's best interest. It's not something that advocates hear about a lot as being the dominant issue, but I have had some people really focus on it, maybe because it felt like an easier thing to call out than the nuance of the abuse they were experiencing. So make sure to point this part of the statute out if you're hearing that, because there's potential for it to really undermine them and I think look petty to the judge. So something to focus on. Let's see, a disability alone doesn't mean that they can't have custody. Disagreement alone over what custody should be doesn't equal an inability to cooperate, which is important to specify because it's a caveat to that 12th best interest factor, which examines their willingness to cooperate. Joint custody does not require an equal division of time, and the court may not consider only a parent's past or future deployment. Okay, let's look at a couple examples of how using these factors can help someone describe the harm that's done to the children by abuse that is not statutorily defined. So these are examples not of physical abuse that would that you would bring up to get a finding of abuse, but rather some of those other abusive dynamics that the court doesn't recognize as abuse, but your client feels is relevant to who should have custody. So let's pretend that they're telling you they want to point out that the other parent verbally abuses them in front of the kids. I think that some people feel like this type of thing speaks for itself. So being clear that it does not. Just like in writing an order for protection, you need to provide specifics. Spell it out. Don't let that impact on the children speak for itself. So instead, you might provide an example. Jake didn't like that I cut my hair short and told me in front of our kids that he can't believe he's married to someone so ugly. He told me I better not cut it again without asking him first. My daughter has now begun saying, Mama's hair is ugly. And then maybe you can add something about the emotional harm that you feel this causes your daughter. Something like, I'm afraid this is teaching her that women's and girls' value comes from what they look like to men. And I think you have to be careful not to overreach here. Parents do have a right to teach what some might consider toxic belief systems to their kids. But if you have some examples with an easy to articulate effect on your child like this, it might be worth to bring up. And it demonstrates that you are thinking about and centering your child's developmental and emotional needs. One more, and this would be speaking to the fifth best interest factor, which asks if there's any chemical health issues of the parent that affects the child's safety. So instead of saying Tim drinks too much and is dangerous around our daughter, we have Tim had 3 years of sobriety when we met. After our daughter was born, he started drinking again. He's now drinking close to half a liter of hard liquor nightly and gets so intoxicated that he's fallen down the stairs twice in the last month. He insists on carrying her to her crib upstairs when he's in this state. I feel like I need to protect her when this happens, but if I try to take her from his arms, he starts pushing me away while holding her, which makes him stumble with her. So again, relying on specific and facts and details to speak to that factor. And then last point on these factors is to suggest to your client that they anticipate and address the other parent's points and accusations. A very common one that people are worried about that we know abusers like to use is accusations of mental health issues. And this is usually a really great opportunity to turn it around and point out the abuse again. So if you have someone who thinks their abuser is going to bring up that they have severe mental health issues because they were hospitalized for a suicide attempt and had to be away from their kids for 3 weeks, you can help them prepare to respond to that accusation with something like this. The daily abuse was just making me feel so hopeless. He'd cut off contact with my family and screamed at me anytime I didn't keep the house clean or the kids quiet. He told me all the time that I was worthless. I knew if I ever stood up for myself, he'd hurt me. I just didn't feel like I had a way out. The treatment facility was actually the first time I was able to get perspective on the abuse and get connected to resources to leave him. I was also prescribed medication for the PTSD he caused. This was the turning point where I started finding the strength to leave him. Okay, so now we are going to do a little shift again and talk about ancillary court professionals. And these are people who are appointed or hired when there are custody or parenting time issues. And you can think of them as having a supportive role in helping the court make informed and equitable decisions. So they're often social workers, GALs, psychologists, attorneys. Their purpose is to obtain information about both parents and provide recommendations to the court. And what's often surprising to people is that they may have limited training regarding domestic abuse. So it's important to understand that they are not friends or advocates for the abused parent. However, with that said, it might be useful for your client to treat these individuals like partners with a common goal of determining what's best for the child, because ultimately they hold a lot of power. And being argumentative or angry towards them is just not going to be very helpful. I've talked to a lot of victim survivors who describe a very adversarial relationship with some of these people. And that's usually because they're not taking abuse allegations as seriously as they should, or the person thinks they should. And I can usually tell that there's a disconnect between what the survivor thinks the person's job is and what it actually is. Or they're just not understanding the statutory limitations on the definition of abuse. But either way, it's really important to maintain pleasant communication with these folks. So real quickly, who we're talking about specifically are guardian ad litems, custody evaluators, mediators, parenting time expediters, parenting consultants, parenting coaches, both confusingly referred to as PCs, or even therapists. And we will go over a few details on a few of these. So a GAL is an attorney who is sometimes appointed to the custody case where there are major issues around child welfare. And while these are attorneys, a really important distinction is that they are not the child's attorney. So they're not there to advocate for what the child wants. They're there to assess what's in the best interest of the child based on those 12 statutory factors, and then advocate for their determination, which might not be the same thing as what the child says they want. But they have broad rights and access to the child and any information relevant to the family situation. And their recommendations are almost always adopted by the court. So if a parent disagrees with them, they can, of course, ask for a trial, but the chances of a judge overruling what a GAL recommends are really slim, because they are basically considered arms of the court who are very credible and thorough and very qualified to make their determinations. And then just to note that how they're paid for depends on the financial situation of the parties and the jurisdiction. Another one here is a custody evaluator. They're frequently mental health professionals or social workers with the goal of assessing the broader family dynamics as sort of another pathway to determining those best interest factors. They are also given broad access to the child, the family situation, and the case at large. And they may not be appointed or hired as frequently as GALs because they tend to be a lot more expensive. And here we have those used in alternative dispute resolution. So those cases where there are disagreements that the parties are trying to work out outside of the courtroom. A mediator is pretty straightforward. It's noteworthy, though, that they can't issue binding orders. A parenting time expediter clarifies existing parenting time orders and facilitates communication between the parents. And they do have the authority to make decisions or issue recommendations regarding parenting time disputes. And then lastly, a parenting consultant comes in usually if there are disputes after the court order is already issued and both parents agree to their involvement. And again, they have binding decision-making power. Here are some helpful suggestions that advocates can make to their clients around working with these folks. The first is to know what you want for custody and parenting time and have some variations of that prepared that are based in reality of what the court might actually agree to. Be prepared to explain why what you're asking for is in the best interest of the children. Again, connect everything to the kids. Anticipate the other parent's points and be prepared to address them, as we said, and then expect that all of your communication is going to be seen by these people. As an advocate, I'm always talking to people about the importance of being disciplined in their conversations with their abusers, because those communications can really undermine you if you're not. I think a good tip is to say that it's not about winning the argument with the abuser. It's about demonstrating to the court that you are the one who's acting in the best interest of the children. And next thing is maybe obvious, but encourage them to treat everyone with respect and courtesy. Like I said, be available, be reliable. Getting into arguments or avoiding them is going to do the opposite of what you want it to do. You can ask them as well or what to expect during the home visits. And if the meeting or phone call is making you upset, just ask to take a break. Asking to take a break is a far superior to getting into conflict. And then before I hand it back to Sammy, just a few warnings that you might want to give them. Minnesota statute provides a presumption that a child deserves a relationship with both parents. So they're going to be looking to do that whenever possible. And next, that family court professionals have limited awareness around domestic violence. They might just not believe you. It's not typically a conspiracy. It's just an unfortunate reality that you might have to be prepared to work around. All right. Pass it back to you.
All right, so next we wanted to go over some rights that apply to victim survivors in family court. And the first one, the one that probably comes up the most frequently, is that victim survivors have a right to opt out of mediation. So under the general rules of practice, all family law matters are subject to alternative dispute resolution, except for orders for protection, contempt, and child support if the county is a party. But under those same rules, the court cannot require the parties to participate in these processes if one of the parties claims to be the victim of domestic abuse by the other party, or where the court determines there is probable cause that one of the parties or a child of the parties has been physically abused or threatened with physical abuse by the other party. And so one thing that's important to note about the language of that rule is this does not require the judge to make a finding that domestic abuse occurred. The language of the rule is that if one of the parties claims to be the victim of domestic abuse by the other party, the court cannot require them to participate in a facilitative process. So some judges think, maybe there's an order for protection without findings, or maybe there is no order for protection, and they think, well, I haven't made a finding yet that domestic abuse occurred. It actually doesn't matter for the purposes of this rule if there's been a finding or not. It just matters that one of the parties claims to be a victim. A lot of judges will strongly encourage mediation anyway. Judges like mediation, especially in family court. They really like when parents can reach agreements themselves. They think that, if you go to mediation and up with a parenting time schedule, it's probably going to work better for that family than something the judge comes up with. And I think in a lot of cases that's probably true, but not necessarily in cases where there's been domestic abuse. So one thing that advocates can really help prepare clients for is to know that they have the option to opt out of mediation. You can give your client a copy of this rule, because sometimes they will really have to push back against the judge. The judge is going to tell them how great mediation is and tell them that they really like when everyone participates in mediation. But if you're working with a victim survivor who, feels pretty strongly that they don't want to participate in mediation, having those rules to cite can be a really good way to just tell the judge, Your Honor, I know under general rules of practice 310.01b, I can't be required to participate in mediation because I have claimed to be the victim of domestic abuse by the other party. Some judges, if they're really stubborn, unfortunately, still won't listen and might order mediation. But for most judges, once you cite that rule and the actual language of the rule, it's going to kind of remind them that they can't order a victim to participate in mediation. Some judges also have a tendency to put mediation requirements into a final order. So they'll say, here's the custody and parenting time schedule. If there are disagreements in the future that can't be resolved between the parties, they must go to mediation before filing a motion in court. And sometimes this rule can excuse someone from those requirements too. Not all the time. It sort of depends on the judge, but I have seen cases where someone is able to say, we have a mediation requirement, but I am a victim of abuse, and so I should not be required to mediate. And I have seen cases where the judge waives it. One thing to keep in mind, though, is that mediation, it's not a one-size-fits-all approach where every victim survivor of abuse should say no to mediation. It really comes down to the preferences of that individual person and whether they're going to feel safe in mediation and whether they're going to feel comfortable expressing their views to the mediator and saying no to recommendations that they don't think are good for their family. I have worked with victim survivors who prefer going to mediation over going back to court. They want those mediation clauses in a final order because it provides a little bit of a barrier against future litigation abuse because they know their abuser can't just suddenly file a motion saying, change the parenting time schedule, change custody, whatever they want to ask the court to do. They have to go to mediation first. And it just creates like an extra layer of work for the abuser that they might not go through because usually mediation, they don't want to do mediation. They want to just go straight to court. And if there is that barrier there, they might not do it. And so it's important to talk with your clients about what mediation is and whether they want to participate in it or not. You can't just assume that they would or would not want to participate because different people are going to have different opinions and preferences on that. And so what they need to know is, what's going to happen in mediation, what do they need to be prepared for? And we'll go over that in a little bit more detail in a couple minutes. But first, there is a form that can also help victim survivors remind judges that they are exempt from mediation. And I have a screenshot of the form on the next slide. So this is called a certificate of settlement efforts. And the general rules of practice say that this form is supposed to be filed before any motion hearing. The person filing the motion is supposed to file this to say, I tried to settle my motion before we had this hearing. Most people don't file it. Most judges that I've seen don't really enforce the requirement to have this. They're not really going to dismiss a motion just because someone doesn't file their certificate of settlement efforts. But sometimes for victim survivors, I find it helpful to file the certificate of settlement efforts because it has a box to remind the judge that this person is exempt from mediation and that the judge should not be questioning, why are you filing a motion instead of going to mediation? And so this form can be found on the state court's website, mncourts.gov. And if you go to court forms on that website, there's a general family forms category. And it's got several kind of miscellaneous forms that don't fit well into the other categories. And this is one of them. You'll find the certificate of settlement efforts there. And so you can file it before a motion hearing and check the box saying the parties are exempt from settlement efforts because, and then I list these reasons, and the last box is the language of that rule that I went over. One of the parties claims to be the victim of domestic violence by the other party. And if we go to the next slide, there's another portion of this form that addresses whether there's a court order requiring the parties to use mediation. So if there has been an order issued that says you have to go to mediation before filing a motion, you would have to check this box, but then there's a box right below it that just says, I have other good reasons for not having settlement discussions. And so if it is a case where the court order requires mediation, but that party is not comfortable going to mediation because of the abuse, they can check the box for having other good reasons for not having settlement discussions and just explain again, I'm a victim of abuse to mediation with this person. So in order to make the decision about whether they want to go to mediation, there are some things that clients need to know about it. The first is that it's usually confidential. If they're using a private mediator, maybe check the mediation agreement with that individual mediator, but the vast majority of mediators are going to have an agreement that says this session is confidential. Nobody can call the mediator as a witness. No one can testify about what happened in mediation. Nobody can tell the judge what the mediator was recommending or who didn't want to accept the recommendations. And so that can be really helpful because then you know, there's no there really is no penalty for rejecting the mediator's recommendations because the only thing the judge is going to find out is that you didn't reach agreement. They're not going to know who caused the parties to be unable to reach agreement or who didn't want to agree to what the mediator recommended. They should also know that they're going to have to be prepared to articulate their position and their reasons for it. So similar to how they might have to prepare for a trial, where they would have to explain everything to a judge who knows nothing about their case, and they're going to have to go into, the history of the relationship and the abuse that they suffered and how that has impacted their child. The mediator also knows nothing about their case going into mediation. And so they're going to have to present all that same information to the mediator. And so they need to be prepared to do that because the mediator isn't necessarily going to always ask, was there abuse in the relationship? The mediator might ask some questions that they think are relevant, and that's going to vary by mediator. But the clients need to know, even if the mediator doesn't bring it up, it's still important for the mediator to know that domestic abuse did occur. And so the client needs to be prepared to bring it up themselves. And if there are other really important factors about the relationship or about the other parent's relationship with the child or their treatment of the child, they need to be prepared to affirmatively bring those up. And then similar to what Maddie said earlier, they also need to kind of think about what the other party is likely to say and be prepared to address that. So if the other party is going to say that the client has a lot of mental health issues, be prepared to address, what mental health diagnoses do they have? Are they getting treatment? Is it something that the abusive party is, just blowing out of proportion, trying to make it a much bigger deal than it is, just because this client might be in therapy for PTSD from abuse? So they do need to be prepared to talk about those issues. And they also need to know that in mediation, in most cases, it's going to be a situation where the abusive party can hear what they're saying, and they're going to hear what the abuser is saying. And that can be really, really difficult for some victim survivors. So that is something to consider when you're helping them kind of think through, should they opt out of mediation or not? And you also should let them know, the mediator is going to make recommendations. You don't have to agree with the recommendations. But is this client someone who is going to feel pressured to go along with those recommendations, even if they don't actually agree? If so, mediation might not be the best option. But if they feel like, no, I know what's best for me and my family, if the mediator doesn't get it, I can say no, and I can explain what actually happened. Mediation could be an option. So again, it just comes down to the client's personal preferences and whether they're going to feel comfortable and safe in that process. You can also let them know they can end mediation at any point. Just because it's scheduled for 3 hours doesn't mean they have to be there for 3 hours. If it becomes clear an hour and a half in that this is not going to be a productive process, or they're feeling more triggered than they expected, not really able to sit through and hear everything the abuser is saying, they can end the mediation, and there's no penalty for ending the mediation early. So those are all things that they can think about. Also, mediations, they don't always have to happen in the same room as the other party. A lot of mediators are willing to do virtual mediation. So it might be on a Zoom call or a Teams call, which can help some clients feel safer. Some mediators are also willing to do shuttle mediation if it's in person, where they've got the victim survivor in one room and the abusive party in another room, and the mediator goes back and forth between the rooms so that the two parties aren't actually in the same room at the same time. And that can be helpful too. I think it's more common these days to do a virtual mediation instead of doing that shuttle style mediation. But either option is available, and they can always talk to mediators. If they're choosing a private mediator, they can always talk to them about, what are your safety procedures, and make sure that it's something that they're going to feel comfortable with. One other right of victim survivors that we wanted to go over is something that Maddie talked about a little bit, but we just wanted to really emphasize. There is a statutory presumption against joint custody when domestic abuse is present. But in order for the court to get to that presumption, there has to be evidence of the abuse. So again, whether it's in mediation or in a trial, is going to have to present evidence that abuse occurred. And it would be the same type of evidence that they might present in an order for protection hearing, because it's the same definition of domestic abuse that's used in order for protection cases. So they can testify about the abuse. If they have exhibits, they can use exhibits to help prove it as well. And then they should also support the presumption, because it's not an automatic guarantee that once you prove abuse, the judge will award sole custody. So they have to kind of support that presumption by showing how this abuse impacts co-parenting. How does it make cooperation and decision making impossible in this case? And also, how does it show that the victim survivor is the one who should have sole custody? Because it's a presumption against joint custody. It's not a presumption that the victim is the one who should have sole custody. It is possible to award sole custody to the abusive party if the judge finds that's in the child's best interests. So the victim survivor also needs to be able to show how awarding them sole custody is what's best for the child. So if they've been the primary caretaker of the child, testify about that. If they've, always been the one to make sure the child goes to their doctor's appointment, gets to school on time, testify about that. And if there are disagreements about big legal issues for the child, like what kind of school to attend or what kind of medical care to receive, it is really important to testify about those disagreements and explain to the court how the victim survivor's position is the one that's in the child's best interests. And so this is just kind of a flow chart to summarize how a victim survivor could get sole custody of their child. So the first option is if the court makes a finding that domestic abuse has occurred, then that presumption kicks in for one of the parents to have sole custody, and the victim survivor is going to need to present evidence that they're the one who should have sole custody and it's in the child's best interests for that. If for some reason the court does not find that domestic abuse occurred, then there will be a presumption in place for joint custody. That presumption is rebuttable as well. It's difficult to rebut it. A lot of judges don't like to find that the presumption is rebutted, but it's not impossible. The client in that case should really focus on evidence that the parties truly cannot make decisions together. So maybe there hasn't been domestic abuse as defined in Minnesota statute, but maybe every time she texts the other parent and says, what school do you think our child should attend when they start kindergarten next year? Maybe his response is always, don't talk to me, I hate you. That's not effective co-parenting. That's not a situation of joint custody. So even if the judge doesn't find that domestic abuse occurred, there's still other types of evidence that someone could present to try to rebut that presumption for joint custody and try to convince the judge that they should still have sole custody. So one other thing we wanted to talk about is in final orders. It is really important to try to get as specific a final order as possible. So a specific schedule for parenting time, specific location for parenting time exchanges. If one parent's parenting time is going to be in phases, maybe it's a graduated schedule where they're starting out with some day visits on Saturdays and then eventually they'll get overnights. There need to be specific durations for each phase. Something like 90 days, or if there's some very clear requirement that parent has to meet, make sure it's a requirement that's easy to prove. Otherwise, there's just going to be disagreement over whether they've moved to the next phase or not. And one thing to consider is including language about what happens if one parent is late or if they don't show up for an exchange, because that happens really frequently. If one parent is 15 minutes late to a parenting time exchange and the other parent has been waiting there and they don't have any, text or call from the other parent saying when they're going to get there, How long does that parent have to wait before they can just take the child back home? That's something that can cause a lot of disagreements, even when an order is in place. And so it can be good to just anticipate that and have that language in the order from the beginning. And we have some examples on the next slide of effective language. So for parenting time, I see a lot of orders that just say something kind of vague, like father will have parenting time as agreed between the parties. And sometimes that's because the parties come to an agreement and they think they're going to be able to work it out. Sometimes it's because the judge issues that order and the judge believes the parties will be able to just work it out. That is generally not going to be an effective order, especially in a case where there's been domestic abuse, because that's just going to lead to conflict between the parties. Because then it says as agreed. What happens when they disagree? Dad thinks he should have an extra weekend. Maybe mom is willing to let him have a little more time, but not the full weekend. It just leads to unnecessary conflict between the parties. What would be better is to have very specific language about the duration of each parent's parenting time. Something like, father will have parenting time every other weekend from Friday at 6 p.m. until Sunday at 12 p.m. His first weekend of parenting time will begin August 2nd, 2024. And so that's really clear to both parties. They know exactly what day will start. And it's helpful to even include that language about what the first weekend of parenting time will be, because when you're on an every other weekend schedule, sometimes there might just be disagreement when you first get the order, like which weekend is the first weekend. But it can also help a little bit with enforcement later if one parent is withholding the child one weekend. If you have the date that it started, it's easier to prove which parent should have parenting time this weekend, because you can look at a calendar and say, well, if we run every other weekend and you go from August 2nd until this weekend, here's who has parenting time this weekend. And can you go back, Maddie? The same principle kind of applies to the exchange location. So sometimes orders will just say the parties will exchange the children at a mutually agreed upon public location. And that's going to have the same issues where, maybe they agree for a while, but then somebody wants to change the exchange location and the other person doesn't agree. They're going to end up just constantly disagreeing with each other, and probably one of them is going to file a motion eventually asking the court to resolve this. What could happen instead is the order could say the party beginning parenting time will pick up the children from school. And if school is not in session when parenting time begins, the parties will exchange the children at the Target located at and give the specific address of the Target store that they're talking about. And the reason that's really good is that picking up the children from school, that's really clear. Just when school ends for the day, the party beginning their parenting time is picking up the kids from school. That also eliminates contact between the parties. It doesn't require them to actually see each other when they're changing who has parenting time, since the pickup is just happening at the end of the school day. But it is also really important to have that provision about if school is not in session, because there are going to be parenting time exchanges when school is not in session. It might be a 3-day weekend, or it might be spring break or the summer. And so it's really important for the parents to know, what if school isn't in session? When do we pick up the kids? And what time do we pick up the kids as well? And to get that specific language in those final orders, there's a couple ways you can really try to advocate for the judge that this is necessary. One way is if you have a trial, you can actually submit an exhibit of your proposed schedule and show the judge exactly what you think the order should say. And one reason that's helpful is because it kind of gives this visual for the judge to look at when they're writing their order later. And they could say, oh, this is what this parent proposed. And they can look at it and think, maybe that is a good idea to have it be laid out and specific like this. Allow written submissions after a trial, and that can be another good opportunity to explain exactly what schedule someone is asking for. And Also, in testimony during trial, it is important to explain to the judge why the specific language is necessary. Because if you're asking the judge to include all this really specific language, some judges are going to say, why are you trying to just, micromanage this order? Why can't you two just cooperate if I put in that you're going to cooperate and find an agreed upon time? And so it can be important to explain to the judge, we've tried to cooperate and reach these agreements in the past, and it doesn't work. We end up disagreeing. Here's what happens. And give some specific examples maybe of times that they've tried to agree on exchange locations or tried to agree on changes to a schedule and it hasn't gone well. And just let the judge know, like, the reason I'm asking for this is so that we both know really clearly what's expected and we don't have to come back to court later because we disagree. Because as much as the judge maybe doesn't want to have to go put all of the specifics that you're asking for in the order, they also don't want you to come back to court and file new motions later. So if you explain it in a way that shows them that this really is necessary, they're more likely to include that specific language. And now I think we are just over time, but if anyone has additional questions and wants to stay on, we can maybe stay for a couple minutes. Otherwise, our contact information is there.
Awesome. Well, thank you so much, Maddie and Sammy. That's such valuable information for us to have as advocates. You've got their contact information here, so feel free to reach out to them. And I think I'll end the recording now, and then if folks have questions, they can throw them in the chat and see if Maddie and Sammy have some good answers for you.